Thank you, colleagues. I want to thank my co-carrier, Representative Barnhart, bringing this bill forward last session, not giving up this session. I joined the team on this bill last fall when a police officer living in my district came to me frustrated after pulling over these driving while suspended offenders time and time again, only to issue them yet another ticket and watch them drive off, yes, again, without a valid license. In his testimony in the Judiciary Committee, my constituent, Sergeant Bill Gill, said, "I often have the fear that a similar driver will be involved in a serious injury or fatal accident while having a copy of a DWS, driving while suspended, citation in their immediate possession." And he pulled out a couple of rap sheets from Marion County showing individuals with up to 77 driving while suspended offenses. And he summed it up best. If this bill becomes law, if House Bill 2384 becomes law, it will provide a vital element in an officer's ability to get these drivers off the road and also provide a serious deterrent to such irresponsible behavior. There have been questions about what kind of universe of people are we talking about here. Well, if House Bill 2384 was now in place, there would be about 1,350 offenders out of the approximately 185,000 people in Oregon who have had their driver's license suspended in the past year or so. So it's a very narrow group of folks we're targeting here, and probably the most dangerous, potentially dangerous ones. And these are offenders that have been convicted of driving while suspended or revoked for reasons such as manslaughter, driving under the influence of intoxicants, reckless endangerment, reckless driving, causing serious physical injury to someone while they were driving with a suspended license. It's an important tool, but it doesn't have to be used by a police agency. It just provides a tool. And if an agency decides they want to use the tool, they have to come up with procedures to use it. But if they decide they don't want to use this, they don't have room to impound cars, or they decide they don't want to mess with this for whatever reason, they don't have to use this tool. And it requires agencies, like I said, to establish their own rules. But I want to repeat that in this bill, we are not changing the forfeiture statutes. All the current protections in the law, the forfeiture statute, are still there, all intact. All the current checks and balances and notifications are the same. And there are questions raised in committee about so-called innocent owners, people that drive a work vehicle or a rental car, or the bank owns the car. Law enforcement still has to determine title holder and proceed with notification, etc. Prosecutors can't forfeit cars that are not owned by the driving while suspended offender unless the prosecution proves that the innocent owner was part of the criminal behavior. And there would still have to be a conviction for a crime, not just an arrest or an accusation. There are many steps that have to be completed in the forfeiture process, and just to make the legislative intent clear on the record, I am obligated, to read into the record an opinion from the Legislative Council on this issue. The question was, what impact, if any, passage of House Bill 2384 would have regarding the interests of rental car companies, employers, and financial institutions? Legislative Council replied, the answer is those entities are protected under the Oregon Constitution and the procedures set out in ORS Chapter 131A under Article 15, Section 10, Sub 3 of the Oregon Constitution. Forfeitures are prohibited without a conviction unless the person consents to the forfeiture, acquiesced in the criminal conduct, knew or should have known that the property constituted an instrumentality of the crime, or took the property with intent to defeat forfeiture of the property. Unless the vehicle falls within one of the narrow exceptions, a judgment of forfeiture may not be entered until and unless the person claiming the property is convicted of a crime in Oregon or another jurisdiction. Thus, assuming a rental car company or employer or other owner of the vehicle who is not subject to forfeiture has not consented to the forfeiture, failed to respond, or somehow acquiesced in the criminal conduct, the vehicle could not be forfeited. As for a financial institution, Article 15, Section 10, Sub 8 states that if a financial institution demonstrates an interest in the property, then that interest is not subject to the forfeiture. Thank you for bearing with me. I hope you vote aye. Thank you.